ask these in your name. Amen.
Thank you very much, member. Are there any apologies for absence? I have three. Senator Currency Morrison is overseas on government business. Member Marissa Dalrymple Philibert is dealing with an issue in her constituency. And
Matthew Samuda, he has a conflict of interest.
Any other apology? Another member Golden is on his way. And nothing from member Witter. Okay, Witter is on his way. So member Witter and Golden. Members Witter and Golden are on their way. Okay. Let me use this opportunity to, well, before going any further, let me ask the committee to move a motion for us to accept Mr. Ordinary Tucker, who is inappropriately dressed, to sit. For us to accept him as he is. He's right there. Mr. Tucker, in fact, you should not have been allowed to even sit within the chamber until you are given permission to do so. Notwithstanding that, we are going to ask the members to move a motion. He had a little bit of an emergency, I believe. So he forgot his jacket. Moved by Member Robinson, seconded by Member Cuthbert Flynn. Those in favor? Those against, the ayes have it. We have with us this morning, members. Let me start with our students. Students from the University of Technology, Meadowbrook High School, and Avondale Preparatory School. They are with us in the audience, and let us give them a warm welcome. Northwest St. Andrew? I'm glad that, member, you're familiar with a constituency other than your own. I wonder why the interest. We are with us this morning making presentations. We have the Broadcasting Commission, the representatives from the Jamaica Chamber of Commerce, the Media Association of Jamaica Limited, and the Financial Investigations Division, FID. Of course, we have with us our support team, members from the Chamber, the Attorney General's Chambers, the Office of the Parliamentary Council, the Legal Reform Department, and of course, the team from the Ministry of Science, Energy, and Technology. Again, let me say welcome to all, and we look forward to a very fruitful sitting today. Members, can we have a look at the minutes? Are there any corrections, omissions to the minutes? The minutes was circulated earlier, I believe. Moved by Member Robinson. Okay. Seconded by Senator Donna Scott Motley. Those in favor? Those against, the ayes have it. Let me use this opportunity to thank the team from the Parliament for doing a tremendous job. I do not recall us having to make any correction or any significant corrections to the minutes since we have started sitting as a Joint Select Committee. So commendation to the staff here. I must say, Miss Brandon, we appreciate the fact that you're on point to the point where, you know, we are on the border of being too informed, if one could make such a pronouncement. But commendation to you and the team here at the Parliament. At this time, we are going to, matters arising. Any matters arising from the minutes? Matters arising? All right, matters arising. Close. At this time, we are going to take the presentation from the Broadcasting Commission. I just ask the presenters to identify themselves when they are making the presentation for the recording clerk to be able to capture the speaker who's making the presentation. Well, I believe we all have a name card before us. Notwithstanding that, I think it would be helpful as well for you to identify yourselves, the members of your team, and whenever someone is making a presentation, just identify yourself again. Thank you very much. Broadcasting Commission.
Good morning, Minister, members of Parliament. Thank you for inviting us. I'm Professor Anthony Clayton. I'm the Chairman of the Broadcasting Commission. And with me are 3 members of my executive team. Cordell Green, the Executive Chairman, Caroline Salmon, and Nicole Wolford, who's sitting in the seats immediately behind us. And we have a brief presentation for you this morning. Could we start our presentation, please? Okay. Now, by very quick background, if I may, we have we're in the middle or the early stages of the 4th Industrial Revolution, which and a number of studies have indicated that over the course of the next 2 to 3 decades, something like half of all current jobs in developed economies can be replaced, now done more efficiently, more cheaply, more reliably by artificial intelligence and robotics. In some of the developing economies, it's probably closer to 80%. These changes are probably inescapable. I'm sure that many new jobs, new economic opportunities will be created, but many of the existing ways of forms of employment will disappear over the period. So 20, 30 years from now, the structure of our economy is going to look very different. We don't know exactly what it will look like, but one of the things that I think is very clear is that we have to do everything in our power to accelerate the transition to a digital society and economy, as that is going to be the backbone for most of the other changes that are going to happen. What this means is that we have to find ways to accelerate the transition of business, commerce, government, education, healthcare, media, and many aspects of our personal business and personal lives online. Regulation has a very important part to play in this, for good or ill. If we get the regulatory framework right, it can accelerate the transition. If we get it wrong, it can inhibit it. So when we do a look back, this is a quick run through Regulation 101. We're now going into something like the 5th generation of regulatory philosophy. 100 years ago, regulation was mainly about controlling monopolies, preventing abuses, and substituting for competition. Then, of course, many governments realized that if we get the regulatory framework wrong, it adds significantly to the burden and cost of doing business. So there's a lot of deregulation, the developing of more specialized expertise in regulatory bodies and industry partnerships. But because we then realized that regulation was really a critical factor in the marketplace, thinking about regulation changed again, so that we could actually build in things like how do we encourage more competition, more investment, innovation, and access to market services. More recently, people started to see regulation as part of broader societal goals, like, for example, how do we regulate the media sector to ensure that there is social inclusion, universal access, which of course is very much part of a transition to a digital society. Now, the thinking is very much in terms of how do we enable a transition to a digital society and meet sustainable development goals. This breaks out into a number of targets, like how do we encourage more interagency collaboration, how do we work with industry to get them to improve their efficiency and competitiveness, how do we encourage sharing of best practices, and how do we spur innovation so that whatever is happening in the marketplace, We, as a regulatory body, are focusing on things like interoperability, quality of service, ways to encourage data sharing, and of course, the level of security needed. Otherwise, people will not share data. So there's specific goals in the transition to a digital society, including things like the enabling framework for smart cities, a world in which every appliance has internet capability. How can we develop the infrastructure to monitor flows of resources and people, especially when we have a lot of autonomous systems out there, like autonomous vehicles, aircraft, and ships, and a world in which a lot of existing personal services and professional services, which are currently done face-to-face, medical services, legal, educational, investment services, are all going to be migrating online, which of course they're doing very rapidly already. Now, in all of this, we have to be very clear about what the threats are to progress, and we have to find ways to mitigate those threats. So if I could share with you some of the process that the Broadcasting Commission has been through. We're going through a transition at the moment. There was a world not very long ago, everybody, most of the people in this room will remember it, in which there were clear media channels. You had radio, you had television, telephone, and print media. And these were separate things. So they were organized separately, there was separate legislation for each one, and there were separate regulatory frameworks for each one. That is no longer the case. What you now have is multiple independent networks delivering all of these services. And you have unbundled access across common network structures. So you have now content flowing across many different networks and technologies, multiple services on the same infrastructure. What's happened is that all of these services are really just now data streams. So voice, video, whatever, are just individual streams in a very large torrent of data that's coming to you. So we realized that our task has changed quite fundamentally, that what we are trying to do is trying to regulate just one stream in a very large river, in a river in which other data streams, some of them are not currently subject to regulation. One of the other dimensions that's changed is that many of these transactions are now taking place across borders, which creates a lot of challenging issues about who's responsible for regulating what and where taxation should be levied. In particular, it's now possible to provide news and media services without any local presence in a country at all, or even infrastructure. You just need internet access, which means that many agencies are now beyond current regulatory reach. So the new challenges for us, and I think that these will be this committee will have to address some similar challenges. Firstly, that we've seen the emergence of a new generation of de facto monopolies. There's a very small group of companies that between them control most social media data. And it's very, very hard now to challenge these incumbents because the barriers to entry are very high. This raises antitrust issues about consumer choice and privacy. Now, a lot of people don't realize this, but this extends to a lot of free services and products. There's a tremendous wealth of free software that you can get, and I'm sure you'll all see this coming to your mobile phones, and you click and say yes, and then you get the usual yada yada legal disclaimers. What in fact that often does is it requests access to your or your contacts list, your photographs, and a lot of other stuff that you probably didn't even realize you were granting access to. Once these people have that, they actually have a tremendous reach into every aspect of your life, which some people have realized to their cost. We've also realized the extent to which that this can now be manipulated. And there have been reports of political manipulation via social media now from over 30 countries. In fact, there's a lot of good declassified intelligence reports now looking at the way in which a small group of Russians, probably no more than 50 people, were involved in influencing the last United States presidential election. Once you understand the cultural context, the heavy lifting is, of course, done by botnets, networks of computers and algorithms that can target your audience and make it look like you've got tens of thousands of people posting about a particular subject. Of course, these people don't exist, but you can actually sway political opinion and sway outcomes. So this is something with which we are now increasingly concerned. especially given the fact that the traditional trusted media sources, the regulated media sources, are losing market share. Social media is now a news source for the majority of people, and the primary news source for a significant part of the population, probably about a quarter of the population of Jamaica. And we're seeing the development of new evils, like, for example, the way that terrorist and criminal organizations have also been quick to move into unregulated space. Over the course of a 12-month period, we saw about 54,000 websites with information on explosive devices put up by Islamic State. And 2/3 of this information was shared within 2 hours of posting. So this is because criminal and terrorist organizations and bad guys generally have been very quick to see the potential to move into unregulated space and utilize it for evil purposes. And there are other issues with which we're concerned, like cyberbullying, revenge porn, and extortion. And we've seen young people driven to suicide by people persuading them to make compromising photographs available and then blackmailing them. So there are many, many opportunities involved in the transition to a new digital economy, but equally, bad people have also been quite quick to see this potential, and there are things that we need to do to try and mitigate or prevent these abuses. But the challenge is this, and this is going to be exactly the same challenge that this committee is going to have to face. You're trying to regulate the river. There are many, many things happening now on the internet, and many of them are very good things, and they're very enabling, they're liberating, and so forth. But in there are these new generation of evils, cyber fraud, terrorism, cybercrime, which by some estimates is now a $6 trillion a year business, the development of fake news and the deliberate targeting of fake news to influence electoral outcomes, abuse of privacy, child abuse, cyberbullying, and so forth. So your challenge is, and the challenge for us too, is how do we let the good things happen, make sure the good things happen, but at the same time identify and try to prevent the bad things happening. So this is how we currently see the situation, that it's very important to support and, if possible, accelerate Jamaica's transition to a digital society. As part of this, we have to facilitate the positive things that are happening, but we also have to mitigate the harms. We want good internet service, good media services available to all citizens, and we must have a media and technology literate society. This is not something governments can do on their own. So we have to find new models, new ways to ensure national and citizen security, prevent people's legitimate privacy from being compromised, and develop the capacity to detect and act against abuses such as fraud, extortion, grooming, etc. But we also have a demand from people. The move to a digital society is not going to happen if there isn't seamless access to very diverse content across many, many platforms. So our models of regulation, our thinking about regulation, have to reflect this. Our ideas of our regulation has to be very streamlined. It has to be effective, but it has to be low cost. And it has to be technology agnostic. It's not any one technology you're regulating. This is really about content regulation rather than physical infrastructure. So with regard to the main thrust of our suggestions, is this transition to a digital economy absolutely requires people to be able to feel free and feel confident about disclosing their data. And then people must be able to collect and store and monetize this personal data. But if people have no protection, then they won't do it. And this will seriously undermine our transition to a digital economy. So we have to have some ways to identify and detect abuses. So the issues that you are looking at are very similar to the ones that we are wrestling with too. That content regulation and data protection are now operating in a very similar context and have similar goals. And we need to find ways to develop a model of regulation that's very lean, transparent, efficient, and low cost, which really means that you have to think in terms of the mixture of tools that you need. Some of them will be legal, others may be economic, there may be fiscal incentives or disincentives, sanctions, positive incentives, and educational and advisory interventions. You need to have a range of tools in your toolkit to be able to deliver the results you need efficiently and at lowest cost. We think it's a very important principle that all decisions made by somebody with such a sensitive job should be documented and explained and justified. And there should always be provision for people to complain about an adverse ruling. And there's ways of doing that. The model that has been developed in Canada, we think is particularly efficient. We will come back to that and explain it in a little bit more detail if you wish. But it saves having to set up a cumbersome tribunal system and a parallel channel. What it means is the same commissioner can actually operate in a different function to rule on a complaint. And it sounds like a conflict of interest, but it seems to work surprisingly well. So that's a model that we think that would be worth looking at here. With regard to the sanctions that you apply, here too, it's very important that there's a range of options available to you, ranging from, for example, public shaming through to monetary sanctions, through to, if necessary, the use of criminal charges. And if you're thinking of introducing monetary sanctions, then we think there's a very important principle here too, that the revenue should not disappear into a consolidated fund, that the revenue that you're raising from any breaches, sanctions imposed for breaches, should actually be partially ring-fenced and then used to support digital literacy programs, because the more you do this, the easier your task will become. One of the major challenges is the extraterritoriality issue, because data is now routinely collected, used, shared, and mined between different entities across multiple jurisdictions. Now, under the current draft of the Act, it applies to foreign entities only if they use equipment in Jamaica to process information. And as far as we can tell, at the moment, there's no provision there to deal with firms that collect personal data but don't have a physical presence here. But this actually could, if you're not careful, place local firms at a disadvantage, because many of the biggest operators in this business are not Jamaican entities. And we need to have some way to ensure that there is a level playing field. There are possible solutions. Other countries have also wrestled with these issues. Japan has an approach which places restrictions on the transfer of personal data to foreign countries. Australia's Privacy Act binds non-Australian organizations if they have any business operations in Australia. And in last year, the Federal Court of Canada made a ruling against a foreign national operating outside of Canada who was collecting personal data from people inside Canada, which it ruled violated Canada's privacy law. So this issue about how you treat with foreign entities is going to be extremely important, especially as all of the major players in terms of providing platforms for social media are outside Jamaica. That is going to be an issue. With regard to anonymized data, of course, people will not disclose if they're not confident that the data will be anonymized where appropriate. There's at least 3 or 4 different ways to handle this, but the one that we think seems to be fairly robust is the model developed in Japan, where you actually you impose certain requirements on entities to follow certain rules with regard to how they treat with anonymized data. They have to make a public statement of the kind of items that they're anonymizing, the method by which they're collecting and processing anonymized data, and it has to be kept separate from data with personal identifiers. Now, you can have an encrypted key which links between the two, but that should really be kept by a third party, a trusted entity. So there are ways that you can do this, and you don't really get the benefit of big data applications, and if you cannot access anonymized data. But the paradox is that people won't disclose the data if it's not anonymized. But there are potential solutions to this problem. And our final comment is this, that part of our commitment to the IMF includes trying to hold down the cost of public services, and not create new public entities. So one of the things that you may wish to consider is whether the proposed Office of the Information Commissioner might at some point now or in future be merged with the Broadcasting Commission. That would avoid expanding public service by creating an additional agency, and we are already working on many of the same issues and already have many of the same concerns. Ladies and gentlemen, thank you very much. Thank you, Minister.
Very much, Professor Clayton, for that very comprehensive and insightful presentation. Members, Robinson.
Morning, Professor Clayton. Could you elaborate on the proposal for the ad hoc commissioner versus the appellate tribunal and just indicate how that would function?
All right, let me ask my executive director to take that one.
I think this is an arrangement to avoid a cumbersome appellate process in the administrative regime. My understanding of it is that there would be appointed an individual, more likely a retired, let's say, Supreme Court or Court of Appeal judge, who would have all the powers of the Information Commissioner in dealing with any complaints having to do with the Information Commissioner. So it's really an appeal process, but you avoid a tribunal.
But the only significant difference I'm picking up is you're having one person versus probably three, because the appellate tribunal wouldn't necessarily be sitting permanently. It would be convened when issues arise. So I'm not understanding necessarily the efficiency, and I see a grave danger again in just having one person to whom an appeal would be made.
Yes.
And if you look at normal appellate tribunals, they tend to be minimum of 3, maybe 5.
Well, that's a matter which can be explored. I would want to say to you, member, that my observation is that we tend to craft legislation and put in there provisions for the establishment of tribunals, very often without making arrangements, administrative arrangements for how they're going to function, with an assumption that they're going to be populated by simply describing who would constitute the tribunal, and very often they don't function. So it is not to suggest that an appeal tribunal is a bad idea. It is simply to say, let us look at our experience in crafting legislation which presume that we're going to set up these tribunals, and look to another territory which has a very similar jurisprudence, and to look at how that operation has materialized. I do appreciate the point you're making about the benefits of additional numbers, but we do have arrangements, as you know, even in the justice system, where there are some matters that can be dealt with by one appellate judge and not necessarily a panel. So it is worth exploring.
Mr. Green, on the matter of support staff, would you agree with me that one person or 3 persons sitting would need support staff? What I think you should ask or be presenting is for us to ensure that put in place appropriate support services to ensure that whatever appeal body we develop is effective and works, respond in a timely manner.
That would be a most natural deduction from what we are proposing.
Yes,
I don't think it's either or. It would follow that whatever...
But the point you're making, where one person rather than a tribunal with 3 or up to 5 persons sitting, I think what we need to do is to ensure that we put in place the necessary support system so that appellate body will be able to function, and especially seeing that we live in a very dynamic age now, that the appeal body is responsive in terms of dealing with issues. But I am sure that the committee will take into consideration the fact that we need to have that appeal body, that structure in place, whether it's a single person or a tribunal consisting of a minimum of 3 persons. But we recognize that we must allow for the appeal process to take place. Any other question, Member Golding?
Yeah, thank you, Mr. Chair. 2 points. Mr. Green, if there was any literature on the efficacy of the arrangement in Canada with the ad hoc commissioner that would perhaps describe the strengths or weaknesses of it, or why you think it's working well. If you could share that literature with us, that would be very helpful. I'm aware that we have a proliferation of statutory appellate bodies across a wide range of legislation. And in a small country with limited resources, both human and financial, it's not an optimal approach to dealing with how appeals are dealt with. In the UK, they've had a consolidation of appellate tribunals, specialized tribunals set up for broad functional areas rather than having a multiplicity of tribunals across many, many different pieces of legislation. They consolidate them into a small series of tribunals with specialized skill sets, including judicial skill sets involved. And that's obviously something for a different discussion, but I think that Jamaica needs to look at some kind of consolidation of appeals for these types of matters, non-judicial appeals. But you know, in this area, you've said that the Canadian model seems to work well, and if we could have some further learning on that, it would be useful to us.
We will be very happy to do that. We have some documentation on this which we'll share with you, and also on the other models that we reviewed. Our thinking on this was very much along the same lines, that we're trying to keep down the cost of government. And we also felt, yes, we've got too many separate entities, and if possible, we should try and consolidate them to the greatest extent possible. And maybe, although each one of them needs its own specialist expertise, maybe that could be in the staff, and so that you have people who are at the top level, who are perhaps more from a legal background, who can make appropriate decisions when given the appropriate technical advice.
Chair, just one last point, if I may, and it's to do with the question of extraterritoriality of the legislative reach of this bill. One must be struck by the force of the point that so much of Jamaican data is being processed by persons who don't have a physical presence here, large corporations, massive corporations. Some of the largest companies in the world are the ones that we are using daily and who are accessing our data daily. And I think we really need to focus on having the rights that are being created by this legislation being efficacious, even if it means that we are creating some extraterritoriality to those rights, which is not normally done in legislation, but in this instance it may be necessary for it to have any real impact.
I note, member. Any more questions for the Broadcasting Commission? Yes, Mr. Green.
If I could just respond to that point, I think it's absolutely critical. Organizations like Google and Facebook know probably more about all of us than most people realize. Google said some years ago that they can predict with 98% accuracy when you're going to get divorced in the next 2 years, simply by looking at your search pattern. Now, most people don't realize this, but they actually know more about you than probably anyone else in your life, including your nearest and dearest. Now, all of that information is held on Jamaicans, it's held by non-Jamaican entities, and there are major global challenges now as to how we should treat with that.
Mr. Chairman, there's one other matter that is not in our brief, which we wish to bring to the attention of the committee. That has to do with the provisions in the law on enforcement. There are some provisions here in section 46. The commissioner, if he's satisfied that a data controller has contravened or is contravening any data protection standards, There can be an enforcement notice requiring rectification, etc. There is a requirement in section 49 for the issuing of assessment notices where the commissioner can ask for compliance. There's a provision in section 51 where there can be an information notice that would require persons to provide the commissioner with information. All of this predicated on the notion that the information commissioner will need to gather information before you get to the stage of determining whether there should be criminal prosecution. But then what we find interesting is when we get to section 54, which is the failure to comply, if the information commissioner says, I want some information about what it is you're doing there with personal information, I want some information on whether you're complying with the standards, and the information commissioner is ignored, the person ignoring the data controller commits an offense but shall be liable upon conviction in a parish court to a fine not exceeding $500,000. And we find this to be a bit disturbing because then it raises the question, who would be prosecuted under this legislation? It seems it wouldn't be a very difficult thing to budget for a fine of $500,000 and legal costs and simply ignore an information commissioner. We raise this because we think this is an area the committee could look at with a view to substituting the current provision with a range of administrative financial sanctions as powers that could be given to the information commissioner. And as the chairman said before, those revenues should support digital literacy, because the notion of persons giving consent for the collection of their personal information is really a distortion of consent and permission. Most of us are downloading applications and we're consenting, and we never read the privacy clauses because they are written precisely for people not to read them. So this is an area we would like to see interrogated very carefully.
If I may just mention that the idea of allowing a regulator some flexibility in imposing monetary penalties on non-compliant regulated entities rather than proceeding with prosecution in the courts is known to our law. In the most recent, I think, amendments to the Securities Act, or one of the recent ones, there was a regime put in place precisely along those lines. And I think it is an efficacious system because it allows some flexibility in how the matter is dealt with without burdening the courts and the time taken to effectively prosecute a matter. So, and it's something which is internationally recognized and done. So, it is well known, for example, that the SEC in the US frequently imposes and extracts large fines from violators in the securities markets there and so on. So it is something which we could probably look at that model.
Well, I'm sure the committee is not averse to looking at that, but you will recall that at the outset, one of the main intent of this legislation as relates to fines or fees is to act as a deterrent more than anything else. So while we would entertain a range of, as relates to the fees, I think we need to ensure that the minimum acts as a deterrent nevertheless. So that is something that we will consider during our deliberations later on.
Just one, to pick up on Mr. Green's point, I know one of the issues is what you perceive to be the low fine. Is the second issue related to who is actually the target of the fine? Meaning you mentioned the data controller. Or is your concern it should be somebody who is more senior or more at an executive level within the organization?
Entity itself.
Or the entity itself versus the individual who is acting on behalf of the entity. So the CEO could direct a data controller not to comply, and the data controller is the person who ends up being the subject of that penalty.
You know, I believe, though, at the end of the day, before Mr. Green answers, that it will be the entity that will be the responsible party, seeing that they are the ones that employ the data controller.
Your point, Chairman, wasn't his point that if the regulator, the commissioner, is ignored, the penalty for ignoring it is a modest, what he regarded as a modest fine in the parish courts? I think you use the word data controller when I think you meant information commissioner, and that's what caused the confusion.
I entirely agree. That's the point, member, consistent with what you're saying, Chairman, that if you propose for the penalties to act as a deterrent, then you have to look at how the current bill is crafted.
Thank you very much, Mr. Green, for that, because I recall when I made that pronouncement at our first sitting, a number of persons did not understand where I was going as relates to that, and I thank you for that support.
One of the problems, Chairman, is that when people download software, free software, you have the EULA, the End User License Agreement, which you have to click to accept before you can download the software. The problem is that almost nobody reads the EULA, but nonetheless, the fact that you've clicked it is taken to mean that you have read it, and therefore that the company has your assumed consent. So there's an issue here, which the focus has to be on digital literacy, because it may be that the company that you're trying to prosecute says, but we have their agreement to do this. They've all clicked on the EULA box. So I think here the focus cannot be the traditional regulatory approach. We actually have to focus here on digital literacy to get people to realize exactly what it is that they're agreeing to and maybe signing away.
Well, thank you very much, Prof, for that final contribution. In fact, I think we have a responsibility as well as a public education, and the whole matter of digital literacy is something that we as a government we are committed to. As we roll out our capacity, develop that capacity to participate in the digital society, it is important that one not only utilize the technologies, but ensure that they understand what they're doing. And you're right, it's always in the fine print. It's in the fine print. In this instance, it is in the click. Thank you very much, Broadcasting Commission. At this time, we're going to have the Jamaica Chamber of Commerce.
Good morning, Chairman, honourable members of the committee. Thank you very much for inviting us. My name is Melanie Sabrati, and I'm here as the chairman of the Legs and Regs Committee for the Jamaica Chamber of Commerce. This is my colleague Andrea Kinash, who is a member of the committee, but is also an attorney at law in her own right. Firstly, I would like to say that I need the clicker. Sorry. Firstly, I would like to say that the Jamaica Chamber of Commerce welcomes the move towards legislation that puts Jamaica into an even footing in a competitive global digital environment, and also to provide for further protections for those concerned with information gathering related to the national ID legislation. The point of the Act being to maintain the privacy of living persons and/or data subjects for the purposes of the draft bill. We reviewed different frameworks, and actually we favoured the EU legislation. The model for the draft bill appears to be the EU model. In Europe, data protection legislation was introduced via the Data Protection Directive of 1995, which is currently being modernised. The new General Data Protection Regulation, which was adopted in April 2016, is to be implemented in May 2018. what we're very concerned about, the JCC is strongly requesting a 3-year implementation for larger organizations covered by the Data Protection Act in Jamaica, if not more. We have to get this right. Other acts have long implementation periods. In addition to the 2-year notice of effect of the new EU regulation, it benefits from a further year-long implementation period so that effective organizations can prepare for the compliance requirement it introduces without failing from the outset. And as I said before, we request at least a 3-year implementation period for the Data Protection Act. Secondly, the JCC requests further consultation with the Information Commissioner on codes of practice. The draft bill contemplates that the Act will be regulated by a single regulator, the Information Commissioner, who will be independent of the regulator of the Access to Information Act 2002. The draft bill encourages consultation. In the draft bill, the Information Commissioner has the authority to enter into consultations with trade and other associations for the purpose of drafting mandatory codes of practice. We would like to take up the opportunity by looking at scaling of rules, precedents, making compliance as easy as possible, and including a suite of forms. This is of particular interest to us. Please advise us when such processes start so we are involved in this, and especially to make sure that the standards apply in a proportionate manner. We would also request clarification of exceptions to registration of data controllers. Any organization that is keeping records about individual persons, no matter how innocuous or benevolent the purpose may seem, is subject to the draft bill. This includes both profit-making and non-profit corporations, public authorities and statutory bodies, institutions, associations, organizations, and clubs who keep membership lists and other information. One of the examples that was given, which is why I put the Rolodex on here, is because it is unclear exactly to what extent it applies to all organizations. So, for example, if you take the Brownies, which is an innocuous organization within schools, that they would have sort of identical application of the rules to a large international corporate bank. And I think that needs to be clear. To that end, we note that all data controllers must register with the Information Commissioner unless they are merely keeping a public register. A registration fee, an annual fee, is applicable. Failure to register is a criminal offense punishable on summary conviction to imprisonment or a fine. So we are asking for clarification on exceptions to registration of data controllers. We also, and my colleague is going to speak a little more on this, on who are small record keepers, the size of the companies and customer databases and the like. Our next point is on the processing of data in and out of Jamaica. This is obviously a new era of data in every facet of everyday life. Currently, there is no requirement in the bill for personal data that is processed by data controllers to be stored in Jamaica. We note that the minister suggested that a similar approach will be taken as under the Credit Reporting Act, which stipulates that data must be stored in Jamaica. We believe the bill provides an opportunity for Jamaica to process data from other jurisdictions, notably the EU. However, to do this, the bill needs additional clarity. We note a lack of a detailed framework for legitimate data transfer out of Jamaica, including dealing with the following. The bill should set out provisions for recognition of appropriate foreign and other data protection regimes by the Information Commissioner. We also note that these arrangements may also provide for reciprocal recognition of the Jamaican data protection regimes for the benefit of the local IT industry. In lieu of recognition of foreign data protection regimes, the Act should articulate principles which data controllers must adhere to in personal data transfers outside of Jamaica. These may include appropriate model contractual provisions and other requirements such as those that are set out in the EU regulation. Sorry, I forgot to push the slide. And finally, we feel that there is a strong need to clarify the powers of the Minister of National Security and the Information Commissioner. The Minister of National Security has the power to exempt personal data from the reach of the Act. We note that the exemption is based on state secret and national security concerns. We would simply like more clarification on the circumstances in which such a power would be exercised. Also, there is the power of the Information Commissioner to access personal and identity data of individuals. So we ask that these circumstances in which the power is to be exercised to be outlined in order to manage data security and fundamental rights concerns. So, in summary, the JCC would like a suitable timetable for implementation. We would request further consultation to ensure the interests of our members are represented. We request a clarification of the role of data controller and the exemptions. This is imperative for smaller organizations. 4, we encourage the take-up of the opportunity of data processing within Jamaica because it's good for the economy, and we also ask for clarifications within this area so that these opportunities can be taken up. And finally, we wish that the roles of the Minister and the Information Commissioner are clarified. Thank you very much. We have a couple of extra points, but that Andrea was going to cover, subject to the chairman.
Otherwise,
Go ahead,
we
go
can just
ahead.
take questions, actually.
Oh, you might.
Good morning. Otherwise, we can move to questions if we are running short of time.
No, you can make that presentation because, in fact, let me just ask one question, and maybe during your presentation you will be able to lend some clarity or answer the question. At the outset, you made reference, and in fact rightly so, that this draft bill appears to model the EU model as relates to the GDPR. Now, I am sure that members of your organization, the Jamaica Chambers of Commerce, interacts with citizens from these European countries.
Yes, they do.
What is the level, or how are you responding to the GDPR, which is more or less coming into effect, I believe, May of this year? I believe, seeing that, well, let me allow you to answer that first question.
We note that there is an opportunity for Jamaica to trade better with the EU, given the requirements in that particular legislation, which requires equivalence in data processing with partners. So that's why, as the Chamber of Commerce, certain of our members have identified the fact that it creates an opportunity for them as much as it creates a burden and a potential nightmare for others. So what we have here is a more detailed regime that our members can see coming out of the EU about how data processes must be managed across borders. And there is no foreign mutual recognition regime at the moment, but certainly there is a suite of clauses, et cetera, which suggests that if you are doing business outside of the jurisdiction with data processing, this is how you should do it safely. That's something that we actually want to foster for our membership. In fact, because of the diversity of the membership of the Chamber of Commerce, it is strongly suggested that we would like to get involved in codes of practice, and we would like to make compliance as easy as possible so that people don't fail at the starting gate, which is a real risk. The piece of legislation is substantial. It has been based on a model in a more developed market, more developed economies actually, If that particular piece of legislation has a 3-year notice period for implementation, it would be suggested that that is the bare minimum here. And perhaps a phased approach as between large-scale organizations and smaller organizations that must comply and are not exempt is also desirable.
So the question is, having gotten 3 years to make necessary preparations to be able to be in compliance with the EU's guidelines, regulations, you would appreciate the fact then that you should be well ahead of the game as relates to being far more prepared than most entities within Jamaica.
There are some...
Seeing that we are modeling
Correct.
more or less.
There are some groups that are already trading as groups within the EU. Others may be doing business, right? My colleague Melanie Sabrati is actually affected by this within her own business life. But there are other companies that have been forced to comply. However, we do note that they've been part of the discussion here with the Joint Select Committee about how onerous it is to comply with those particular regimes in Jamaica, albeit that they are complying with them somewhere else in the EU. That we find curious, because we would hope that people like those are trendsetters, actually, that can assist us with the process. As I said, one of our concerns is that we have such a broad membership. So whilst for some of them it is familiar and they are set up to introduce a new compliance process, we keep bringing up the example of clubs and associations like the Brownies, because they are controlling data, including the health data of their various members, and unusually they have to actually exchange the data with the international parent organization. So the bill affects them directly, but can you imagine, they wouldn't even know where to begin actually. So it is really our interest to provide a template-based model for that type of person.
I think I would also point out that people who would be trying to comply with the European legislation wouldn't be the majority of the membership in any shape or form. It would be the larger ones and those involved in data processing itself. But I would say that the membership of the Chamber of Commerce is pretty wide and diverse in terms of the size of organizations, going from very large corporates to smaller, medium-sized ones. And that, that's the objective of the Chamber, is to represent, commercial organizations. So yes, there may be some compliance at the larger side, but it wouldn't fall within all of the purview, and particularly because not everyone is in the data sector in particular.
Chairman, 2 points. One, to support the point raised about the tiering system, which has been mentioned here before, and ensuring that, as was mentioned, for a football club or a citizens association, that the same requirements are not imposed as a large financial organization. But the second point, and I don't know if we have contemplated it in the legislation, exemptions for the judiciary and the security forces here, as opposed to leaving it to the discretion of the Minister of National Security. Maybe we should indicate that they are exempt, or they comply with a version of the Data Protection Act which may be slightly different from what the rest of the business community and the rest of the population is required to, given the nature of the information that they have to deal with.
But I would, just to add to what the member mentioned a while ago, there might be other act that would protect the police and so on, existing act that would protect them, and right, if there's any existing act that would...
There's a certain level of protection, legislative protection, under the secrecy and national security, a piece of legislation. In fact, we were having a discussion recently about that in another forum. But we will deliberate more further on that, members. Ms. Nash, do you still have some points you would like to raise, I believe?
About the record keeping.
I think that One of the points that I wanted to make is that the Act provides a framework for an exemption of a class of person from registration as a data controller, and those are called small record keepers. Because of the points that we've raised in relation to smaller organizations and clubs, I note that people that have to keep statutory registers are subject to this legislation. However, there is this opportunity to say that there is a class of person that does not necessarily need to register. Perhaps they, however, need to comply. So that would be, I think, something that is desirable for the purposes of preparation and implementation, some circumstances around how that would be exercised.
Chair, given the vast range of enterprises that have data and would be impacted by the legislation, and the best standards approach that you want to take, which was supported by Ms. Dalrymple Philibert when she was at a prior meeting, I'm wondering whether, for example, those that are in the business of
Data
managing and processing data would be subject to the full suite of obligations that the Act has. But maybe the type of regime that would be applicable to these small entities, NGOs, charities, and other schools and other health facilities and other entities that are typically resource constrained in many respects and so on. Maybe the template-based model that was being proposed there could be something that could be introduced via regulations that the Act would facilitate, so that you could create some flexibility there, that those could be designed in consultation with the representatives of those types of groups, so that their special needs and capacities could be taken into account in designing the appropriate regime for them. And that could be the subject of regulations made under the Act in due course.
Mr. Chairman, I want to support that recommendation which has been made by Member Goulding. It has been something which has been concerning to me as to how these small entities will be able to comply or even be aware of their need to comply. And I think the template, and perhaps if we can get some assistance from the organization, as they have obviously researched it, I think that would solve a lot of the problems that one can anticipate going forward. Because what we need to do is to make sure that everybody is compliant, but not that it is so onerous and our requirements are so draconian that we actually push them into offending.
Point taken, members. We will have to explore the ways to ensure that everyone is compliant, but at the same time, maybe a tier system in terms of the level of compliance that is needed. But point taken, maybe we can inject that in the regulation.
I just wanted to make the point that we are happy to provide any technical assistance to do with forms and the consultative process.
Chairman, I would also ask that that small companies also have some form of exemption or scaling. I will give you an example of a small wholesale in, say, the outside near Clarendon or something in the country, where they've just converted their cash register to a computer after a number of years, and because now they keep the names of their credit people on there, they are now, basically record keepers. And I think that would be extremely arduous for them to be able to comply, and I think that needs to be taken into consideration, in terms of ability and to comply.
Because the Act has such wide-reaching effect, we think it provides opportunities for educating people about data security and joining the digital economy, but obviously there's the tag of compliance being onerous. Particularly large organizations have already made some of those points, but we really have to think about some of the smaller ones, so that is why we're quite willing to get involved with the process.
Especially given, Chairman, desire to foster and encourage MSMEs and the development and job creation through the MSME sector. We need to design a regulatory regime that they have the capacity to comply with. So,
Members, I see this as a ideal opportunity for us to bring all our citizens up to scratch, up to date as it relates to participating in the digital economy, and appreciating the fact that there is also a certain level of responsibility involved in the process. So I think that even though this is a far-reaching piece of legislation, it opens up quite a number of opportunities for us to educate our people as well. So as we move forward, I think we need to also start to contemplate the public education, public awareness aspect of this piece of legislation and the accompanying responsibilities with data protection and participating in the digital economy. Let me thank Mrs. Sobrati and Nash for participating. You have made some very valuable suggestions, which we will definitely take into consideration. Thank you very much. At this time, we will have the Media Association, Jamaica Limited.
Thank you, Chairman. Good morning, members. My name is Christopher Barnes. I'm the Chairman of Media Association, Jamaica Limited. I have to my left Sheena Stubbs Gibson from RJR Gleaner, Steve Billings, Vice Chair, member from Sun City Radio, Natalie Chin, Jamaica Observer, Lenny Gordon, Nationwide News, Dr. Dennis Howard, RJR Gleaner, and Keith Campbell, PBCJ, all members of MAJ. Mr. Chairman, while the MAJ lauds the objective of the Data Protection Bill to secure the confidentiality of personal data in the possession of entities and to provide for those rights of individuals to access such personal data, we find as drafted, this bill raises major concerns, both for the business of media and concerns with respect to freedom of the press. From our perspectives, some of the obligations imposed under the bill as proposed are inconsistent with the fundamental rights under the Constitution, such as the right to freedom of expression and the right to seek, receive, distribute, or disseminate information, opinions, and ideas through any media. It is clear from a careful reading of the bill that it will have grave consequences on media's ability to provide news to the citizens of this country, and it threatens our democracy. We see in other jurisdictions legislation to protect the work of journalists. This seems to be going in the other direction. A couple of points that we will raise. We've outlined in our submission. One of the areas of concern is in the definition of personal data. What we did was, we concluded that it was too wide. And if this bill were already in law, just a cursory look at some of the publications that we did last week, two publications in particular at the Gleaner, and I'm sure the same would hold for the Observer and certainly for our colleagues who broadcast information every day. We would have, in the Gleaner, we would have infringed this bill over 70 times, as worded, from our understanding. From the Star, it would have been 22 times. And so, and this is stuff that is time-based. You print it today for tomorrow. There's an approval process that you can go through. You can imagine someone like I am on the mic live on TV or on radio in a talk show. The results would obtain because of the definition of personal data, which is data relating to a living individual who can be identified from the data or from the data and other information in possession of or likely to come into the possession of the data controller. And this includes any expression of opinion about the individual and any indication of the intentions of the data controller or any other persons in respect. The definition is too vague. and too wide. In its current formulation, the business of media would be devastated by the passage of the proposed bill. Not only would free speech, the receipt and dissemination of information be shackled, but additionally, the administrative burden that would be placed on the data processors, such as media, which relies heavily on the processing of personal data, will be so onerous as to signal, quite frankly, the death of our business. Having reviewed the bill carefully, we are strongly convinced that the use of personal data for journalistic purposes should be exempted from the bill carte blanche. But in addition, since the right to freedom of expression is wider than the media, we propose the following change to the definition of personal data regardless. After the current definition that you have, add the following caveat: but does not include data which, one, at the time of receipt by the data controller was already in the public domain, two, subsequently comes into the public domain through no fault of the data controller, its officers, employees, or agents. I think this is already in the submission, so I'll skip over some of the proposed language. The second area of concern that we'd like to speak about is in the registration particulars. Sections 15 to 17 of the bill provide that personal data should not be processed by any data controller unless the registration particulars of that data controller are included in the register maintained under Section 17. Registration particulars under Section 16 include a description of the personal data being or to be processed by or on behalf of the data controller. It is not clear to us from the bill whether registration will be ongoing or on a periodic basis, which gives rise to the counting of the number of stories and how many times we think we would have to register based on the wording of the bill. Given the nature of the media business, it could prove very onerous if the media were to be asked on each instance that it handles personal data to provide registration particulars before the information can be processed. It is impractical to impose such restraints on the media unless the intent is to stifle or control the media to aid and abet in the censorship of media. The bill is impractical in its current wording and should not apply to media. We refer to and rely on our detailed submissions in this regard. Section 15 through 17 also provides that a description of the personal data about to be processed must be provided to the Information Commissioner. This requirement is also worrying as much of the personal data received by media while stored is not used for one reason or another, but remains highly sensitive. And to allow the public to have access to same, even just a description of the same, may expose our media workers and our organizations to harm. Another area is the exemption of journalists. Supporters of the bill may argue that there is protection for the purposes of journalism under the bill, but this protection is very limited. To begin with, the exemptions provided for the purposes of journalism are not from the entire bill, as we submit it would be or should be. Rather, if the exemptions are only from certain sections of the bill, not including this onerous pre-registration provisions set out in 1517, nor to the penalties sections. Furthermore, the exemptions cannot be invoked unless certain condition precedents are observed, such as Section 37B, which provides that the exemptions only apply where the data controller reasonably believes that, having regard in particular to the special importance of the public interest in freedom of expression, publication would be in the public interest. And Section 37C, which provides that the data controller reasonably believes that in all circumstances, compliance with that provision is incompatible with the special purpose. The word, Mr. Chairman, reasonably, which appears in both of these sections, is very important, as it means the data controller's determination of whether the particular preconditions exist will be capable of review by the data commissioner or other tribunals. In summary, therefore, the exemption for the purpose of journalism under the bill is limited, as it can only be invoked if certain preconditions are fulfilled. And of the 3 conditions precedents to be fulfilled, the data controller's determination can be overruled on 2. There was another element about pre- and post-publication related to the exemption. As worded, the current exemption seems to address the pre-publication. So for example, it excludes clause 6 or section 6, where one can apply to have the information disclosed as well as the source. While we, in the current language, would be protected pre-publication, after publication, it seems that that person can make the same application under that section 6 and have this information provided to them. This, again, I contend, Mr. Chairman, could put the media house and the journalist at risk. One second. We iterate that the processing of data for the purposes of journalism should be excluded from the bill carte blanche. However, we refer to and rely on our detailed written submissions to the Parliament for the possible amendments. I think the penultimate section or comment is on the powers of the Data Commissioner. The powers of the Data Commissioner are myriad and largely unfettered. For instance, the Information Commissioner is given a wide power under Section 67 to require or obtain information and, quote, no enactment or rule of law prohibiting or restricting the disclosure of information shall preclude a person from furnishing, and it goes on, to him or the appeal tribunal to which appeals are made against decisions of the Information Commissioner. Section 67. Sorry, go ahead.
I'm trying to follow from your submission, but have you moved to, where are you right now?
I'm on a presentation, a set of presentation notes. That's not
Member Golding is not speaking verbatim.
right. So in the submission.
But the submission before you is an overall guide, a guide of the... Well, he's currently on page 5 in terms of content he's discussing now.
Okay, so Section 67 is so widely worded that it means that any information requested by the Commissioner must be supplied under penalty of imprisonment. The provision will remove any protection long enjoyed by journalists up to this stage to protect the identity of sources. It is also worded in such a way as to infringe on the inviolable rights against disclosure of information protected by legal professional privilege, as many law firms, given their nature, will also be defined as data controllers. The bill in its current wording already makes substantial inroads into heretofore uncharted territory, and we see no justification for derogating from long-established enactments, rules of law, and would recommend that this section be deleted simpliciter. We note the many powers given to the Commissioner under the Jamaican Act are given to the courts in the UK. Furthermore, there is no right of the data controller to be heard written into the bill alongside the various powers of the Commissioner to make rulings that will impact data controllers. In the circumstances, we recommend that the Information Commissioner's powers be restricted. We refer to and rely on, again, the detailed written submissions in this area. Mr. Chairman, there are sections that we've highlighted in relation to double recovery and damages, where we feel that damages should be limited to pecuniary damages. And we also believe that damages that are obtained under this act, one should not be able to obtain damages through this act and any other act, such as the Defamation Act. Other areas of concern for the MAJ, Mr. Chairman, include some of these fines. We note one in particular where it says that there's 10% of gross profits of an organization, up to 10% of gross profits of an organization. I repeat again, up to 10% of gross profits of an organization. I think in the context of the media industry and the evolution that is going through, faced with the challenge that Professor Anthony Clayton highlighted in his presentation, I think this needs to be revisited. This will certainly close media houses. So in conclusion, it is incumbent that this legislature, not in the process of securing greater rights for the people of Jamaica, snuff out other pre-existing rights, trample the media, and undermine this country's democracy. So with that, I wish to thank you and open questions.
Thank you very much. Members, any questions?
One question I would like to ask, Mr. Chairman, is looking at the models that we seek to mirror, are there any exemption for the media in those models that we seek to mirror in looking at our, like the EU and so on?
I take note that this bill is drafted off of EU experience. So to the extent that this exemption clause has been written in, we see that there's an attempt. But even with that attempt, we see challenges, certainly in the wording of this. And perhaps it's just in the wording which we can speak about, more consultation. But certainly, as it is written here, if it is that you end up in a situation where every piece of personal data that you are going to publish or broadcast has to be pre-approved in some form by a data commissioner, that is just not on. If it is that under the exemption, you are allowed to publish, but after the publication is done.
Mr. Barnes, can you just answer the question that was raised by the asked of you by the member? In other jurisdictions, how do they treat with exemption, as you are requesting, being the Media Association of Jamaica? And I'm sure, being a media practitioner, you'd have done quite an extensive amount of search, literature search, and otherwise, legislative search.
You're sure, Chairman.
What I can say...
Sure, but allow me, Mr. Barnes, please, I'm chairing here. I am sure that you would have done all your background work, all the research, being a very good media practitioner. You would have done the necessary background work and would be in a position to make, to give an informed answer to this question. For example, it is not only EU that is looking to legislate data protection bills or acts. You know, of course, would have looked at other jurisdictions. Something similar is in Canada, something is in Japan. How do they treat with the exemption that you are requesting, being a media practitioner, and not only you, as well as the Press Association of Jamaica, requesting a particular exemption? I'm sure that there are media houses and journalists in those jurisdictions as well. So, rather than trying to reinvent the wheel, I'm sure that you have that information to provide us with at this time.
Okay, thank you, Chairman. So in answering the question, the research that we have done to this point, admittedly it is not complete. The research that we have done, we have not been able to find anything that addresses the concern that faces journalists and media organizations. if we go to our Caribbean colleagues, the conversations that we've had with them and the information that has been provided is that they've been struggling with this for over 8 years as well in their jurisdictions.
So the answer to the question is that the other jurisdictions that are looking to implement such a legislation, there is no exemption for MAG, the Media Association or the Press Association. Correct? Correct?
What I would say is that they're having
Mr.
challenges.
Barnes, yes or no? Based on your research
He's
to
not
date.
in a dock.
Based on your research to date.
You have a technical team. You can ask them to research it.
Member Golin, allow me to ask, chair this meeting, sir. If you have a problem and you want to ask a question, you ask a question. Control yourself, member. Control yourself. I respect the media, and I know that they are very diligent when it comes to doing research, and I ask a very pointed question.
Yes.
And I'm sure Mr. Barnes is more than capable. You are not his attorney. Mr. Barnes?
Mr. Chairman, the answer to your question is no. We have done, can I continue? The research that we have done, with the research that we have done, we have been unable to find where it works and where it satisfies the concerns about the limitations on freedom of the press. We are willing to dialogue more and research more to present further information that will help you. But what we contend is, as the bill is drafted now, the concerns are far too great for us not to state our position as we have.
And I can appreciate that, Mr. Barnes. I can appreciate that, and I am glad that not only MAJ but other groups really took time out to make a contribution in this deliberation. So we appreciate it. Notwithstanding the outburst, and I must apologize for my committee member.
And I apologize for you.
All right, I apologize for my committee member because he's taking this discussion a bit too personal. And I'm sure that you are more than competent, you and your team, to respond. And I thank you for your response. But this is a work in progress. And so we are open to suggestions, and if you should stumble on any information that can assist us in our deliberation, we will more than welcome it. But a question though, that I would like to ask Mr. Barnes. I mean, we are living in a very, what we can term a digital age, digital society, more or less. And it is becoming increasingly difficult for us to distinguish or identify a journalist. I mean, you know, a blogger, persons on social media provide information. So, how do you suggest that we treat with or identify persons who claim to be journalists? How do we distinguish the real from the fake?
I think that, Chairman, that is something that, again, would require more dialogue, and it would certainly have to involve the Press Association of Jamaica, which is the organization that represents journalists. But where I land on this from the standpoint of a media house, media houses are identifiable, and media houses have journalists that work for them. So what the media house puts out as part of a publication or a broadcast that is under editorial control should be exempt.
Just a follow-up question. I would love to know and to understand why you are seeking to have the media houses exempt when in your presentation you have identified all the areas of concern that you would want the committee to address. So my question is, if those areas are addressed, then why would you be seeking to have an exemption, and while you have identified all the areas of concern?
Well, the approach that we have taken is that we recognize that there's a lot of work that has been done. We recognize the effort that has been put into enacting what is something that is very important to the country. Our first position is that media should be exempt. If, however, you get past the fact that media should be exempt, here are some suggestions that we ask you to have a look at in terms of how the language is drafted.
I think you're taking it from the bottom up, because you should, have us look at those concerns, and then if we are not able to address them, then maybe that should be the point when you now seek an exemption.
Well, I would contend that if those concerns can't be addressed or are not sufficiently addressed, that we would push very hard for it to be excluded totally.
Comment should come then.
Well, Mr. Chair,
Yeah.
Mr. Chair, is there not a distinction to be drawn between a media house or any other enterprise that has data of a private nature as an enterprise, which I'm sure most media houses would do because they're employers, they will have files, they will have information of that nature. And then there is data or information that comes to them in the course of their function as journalists. And I think there's a very important distinction between those two. I don't see why they should be exempt in the first capacity, because in the first capacity, they're just an enterprise like anybody else. But in the course of their role, which is protected by the Constitution, to give effect to freedom of expression and freedom of the press, very important considerations arise. And prior to this, the protection of the citizen from excesses by the media has been through the law of defamation. So if you say something that is untrue about somebody and defames them, then you have a recourse under the law for that. What is now being imposed or superimposed upon the law of defamation is also law relating to what information can be disseminated and how. And that's, I can understand the media's concern that this could be an unwarranted fetter on their role in the democracy that we have. And I think we have to be very careful in the design of this to ensure that the exemptions are wide enough, that the media can play that role without undue interference, undue liability, and so on. And I think Mr. Barnes' point is that whatever research they have done, thus far they haven't found a satisfactory balance being reflected in the law that they have looked at. But I don't know how wide and far-reaching their research has been. But you do have a technical team, Mr. Chairman, who are very able, and perhaps they could look at this aspect of things again.
And I'm sure, member, it is because of the fact that our competent and capable technical team did their research and looked at what occurs in our jurisdiction. That's why this bill is before us without any specific exemption for the press or the media. But on the point of infringing on the right of the press, freedom of the press, I do not believe that we are going to pass a bill into law that will infringe on that right of freedom of expression and freedom of the press. But one has to recognize that there is a thing called responsible journalism as well, right? And if you are in possession of persons' data, then there is a pathway how you must treat with that. Notwithstanding that, the fact that you have freedom of expression as a journalist. So it is something that I believe that when we have completed this phase, we will deliberate more extensively as a committee.
Thank you, Mr. Chairman. I just want to pick up from where Member Golden left, because I do believe that a balance can be struck. And in 2017, Jamaica was placed, I think it was 8th in press freedom. And there is a reason for that. There's a reason why Jamaica was placed above all the other Caribbean territories. I do not know the extent to which the studies have been undertaken, but I do hear Mr. Barnes mention about the Caribbean and his own study. And I believe, sir, that it ought not to be an issue that is not given complete thought. when one looks at what the role and the function of the media, then there is a need to, in my mind, to revise and review the provisions that exist in this bill, because we have to ensure that at the end of the day, while bearing in mind the need for responsible journalism, that we do not create a legislation that stifles or inhibits the ability of the media to do its role. And I want to support the view of Member Golden, because I was just saying to Member Scott Motley that we do have some redress or recourse on the existing legislation, the Defamation Act, in the event that one feels that they have not been fairly treated in the media. And so perhaps in our further deliberation, we could look at the existing provisions in the Defamation Act and see how we could use that provision that exists and balance it with the need and the desire of the presentation that is being carried by the Media Association.
Thank you very much, Member. Any other questions?
Sorry, Chairman, I just wanted to introduce Ms. Stubbs Gibson, who's going to make a contribution.
A contribution, or you're going to make a point? Because we are limited by...
make a point, Mr.
Thank
Chairman.
you.
Thank you very much, Mr. Chairman. Indeed, there are legislation which are in place already, which provide considerable redress to litigants, which have been actively used over the years. The Defamations Act, now we have the Cyber Crimes Act. There is also well-established case law, such as New York Times against Reynolds, the Jamil against Wall Street, all establish and deal with principles of responsible journalism. So there are already well-documented legislation which deal with issues of responsible journalism, Mr. Chairman. And I would also like to remind the committee that while the EU model, we're being told, is what was looked at for informing the template, the bill that is before us, may we also be reminded that there are far more countries, exceedingly more countries in the world that do not have data protection laws in place, largely because of its onerous nature, than those that have. Included in this, Mr. Chairman, would be the United States of America, which does not have a federal data protection data protection law in place. Likewise, in Barbados, they have had it on their books for discussion since 2005, and it has not yet been passed into law. In Trinidad, since 2011, and it's only partially in law, Mr. Chairman. And additionally, some of those European countries that the EU model was drawn from, they have protection for journalists under other legislation which we don't have. For instance, in Canada, in October 2017, they just passed a bill through the House that will strengthen the protection of journalist sources, and that's just as recently as October 2017, and they have data protection laws, Mr. Chairman, and yet still they passed another legislation that would enhance the protection of sources, of journalist sources. We don't have any of those supporting legislation on our law books, nor are we contemplating them, but we're proposing to bring in place the data protection law, and we're very concerned about that, Mr. Chairman.
Any other questions for the Media Association? Thank you very much, Mr. Barnes and your team. We go to the Financial Investigations Divisions.
Good afternoon, Mr. Chairman, and good afternoon to the members of your committee. I am Alethea White. I am the Acting Director of the Legal Unit at the Financial Investigations Division. To my far left is Mr. Robin Sykes. He's the Chief Technical Director of the Financial Investigations Division. To my immediate left is Mr. Odino Toko. He's the Director of the IT unit, and directly behind me is Mr. Andrew Wiles. He's the acting senior legal officer at the FID. Now, the position of the FID and what we are requesting is that we be exempt from the provisions of the Data Protection Act. And we say that given the role and function of the FID as mandated by Parliament in the Financial Investigations Division Act. Now, under our Act, we are mandated to detect and investigate financial crimes. And one of the tools that we use to do that is the processing of data. At paragraph 5 of my submissions, I have outlined some of the ways in which the FID conducts the processing of data, and therefore why we would be considered data controllers under the Act. Now, an example given for the processing of data is that our financial intelligence unit, we receive and store and share intelligence obtained from overseas intelligence units on persons, which include personal data of subjects. We also receive, store, and share reports from entities in the regulated sector, which are mandated to provide certain types of reports under the Proceeds of Crime Act, and those reports include suspicious transaction reports and authorized reports. And we are also able to access government databases, such as the database of the tax admin, which contains personal data of subjects. Now, the information that is obtained by our FIU is used to further investigations and is eventually used as evidence in criminal proceedings. So, given our role and function and how we manage and process data, we accept that we would be considered data controllers under the Act. Now, we recognize that the Act provides exemptions, and the Act recognizes that certain exemptions will be needed. And we are of the view, however, that these exemptions are not adequate for the purposes of the Financial Investigations Division. Now, the first exemption that could apply to us is the exemption outlined in Section 33, and I am now at paragraph 11 of my submissions. That is the exemption where the minister is empowered to issue a certificate exempting any personal data. Minister of Security is empowered to issue a certificate exempting any personal data from all or any provisions of the Act, of the data protection standards and certain parts of the Act, where the minister considers it necessary for safeguarding national security. However, what we note is that this section also allows any person directly affected by the issuing of the certificate to appeal to the court against the issuing of the certificate. If the court finds that the minister did not have reasonable grounds for issuing the certificate, then the court may allow the appeal and quash the certificate. Now, the provision for this appeal we submit may prove problematic. It opens up the minister to judicial review by different litigants. And in order for the minister to be able to defend his reason for issuing a certificate in the first place, he will be required to convince the court as to why he thought the personal data should be exempt. And in doing so, he may reveal investigations themselves, because he will have to convince the court as to the justification of why the certificate was necessary. And we feel that that would be problematic and may even result in committing the tipping off offense that is provided for in the Proceeds of Crime Act. And that tipping off offense, I have laid it out on page 6 of the submissions, so that you can see exactly what I'm speaking about. It provides that a person commits an offense if knowing or having reasonable grounds to believe that the enforcing authority, which is the Financial Investigations Division, is acting or proposing to act in connection with a money laundering investigation which is being or about to be conducted, he discloses information or any matter relating to the investigation of any other person. And that is the offense that prohibits, for example, persons in the regulated sector, such as banks, from telling their customers that oh, I made a suspicious transaction report, and that is why I'm waiting to deal with your transaction. So it's a very serious offense, and we are of the view that how the Act is drafted now can be inconsistent with this provision in the Proceeds of Crime Act. We also note the exemptions provided for in Section 34 of the Act, which is the exemptions for data being processed for the prevention and detection of crime or the apprehension or prosecution of offenders. So we recognize that we could also at the FID fit into that exemption. However, we are of the view that the exemption is not adequate because it imposes a subjective consideration, because the exemption only applies to the extent to which the application of the provisions to the data is likely to prejudice the prevention and detection of crime or the apprehension or prosecution of offenders. So it is only to that extent that it is exempt. We are of the view that that provision is subjective. And at paragraph 18 of the submissions, we further explain this. So we noted that the exemption provided is not absolute. It is only to the extent that it is likely to prejudice the prevention or detection of crime. We are submitting that this imposes a subjective test to the exemption, which it is submitted may prove problematic. The Act does not state who should make the determination of the likely prejudice, nor does it set out any process by which this determination is to take place. Now, this may cause a situation in which a data subject may seek to gain access to their personal data held by the FID and argue that the requirements are not exempt because it is not likely to be prejudicial, while the FID will refuse to allow access by arguing that the exemption applies because it is likely to be prejudicial. Now, if such a situation occurs, there is no provision in the Act which provides for how such a situation is to be resolved. But even if there is provision that, for example, it should go to the commissioner to make the final determination or go to the court, we are submitting that that too will be problematic because the onus would be on us, the data controller, to demonstrate by evidence to whichever tribunal why we are saying that the exemption applies and why it will be prejudicial. And we are submitting that in doing that itself is prejudicial to a potential investigation. The other exemptions, such as exemption in Section 34.2, 34.3, those have the same concerns for us because, again, the subjective element is also there for those provisions. Now, we also recognize that we could also be exempt by virtue of Section 36, and I'm now at paragraph 22 of my submissions, because that section provides for exemptions in relation to regulatory activities, which include the activities of a department of government. But again, the subjective element is also present in that exemption because we have to prove that it is likely to prejudice the proper discharge or relevant functions of the department. Now, the subjective element, we believe, can encourage litigation. A data subject, because of this subjective element, can go to the courts for the courts to decide whether the exemption should apply. And we believe that this continuous litigation would in itself be prejudicial to the investigations that are being conducted. And with the encouragement of litigation, it would also take away from our fundamental function because we would have to now put resources into defending these claims that are brought before the court. We also are of the view that the persons being investigated may use this avenue to go to the courts as a weapon to try to get information in a deliberate attempt to thwart investigations, because they can go to the court and argue that they want to make a request, We have refused their request, so they go to the court to see the reason why they refuse it does not fall under the exemptions. Now, for the court, as I stated before, to decide whether it naturally does involve revealing to the court and to the litigant, who would be the person subject to the investigation, why we say it's exempt, and would involve revealing the investigations and the data that we have to justify why we say it's exempt. We also would like to point out the already existing safeguards that the FID has for the protection of data. The first one that is relevant is the safeguard at Section 10 of the Financial Investigations Division Act, which is the obligation for secrecy. Now, anyone employed to the division in carrying out their functions cannot disclose the information that they obtained in pursuance of the FID's functions. And if they disclose that information, they will be guilty of an offense. So we see that as something that already guarantees the security and confidentiality of people's data. We are also part of our financial intelligence unit is also part of the Egmont Group. And that Egmont Group within itself imposes strict safeguards and restrictions on the use and sharing of information. So that again is another safeguard that we would like to highlight. In recognizing that the exemptions in our submission are not adequate, what we have recommended at paragraph 51 of our submissions, 31, I'm sorry, is that we be placed in the second schedule. Now, Section 42 of the Act makes provision for certain matters to be exempt from the Act, and the matters are set out in the second schedule. It states that the matters set out in the second schedule shall be exempt from the provisions of this Act to the extent specified in that schedule. So we believe that given the deficiencies highlighted in the exemption provisions, it is recommended that a provision be included in the second schedule concerning the FID. It is recommended that this provision should exempt the FID from the requirements of the Act, and the provision should also specifically exempt personal data processed by the FID in pursuance of its functions under the Financial Investigations Division Act and the Proceeds of Crime Act, and should also exempt personal data shared by and with the FID for the purposes of its functions under the FID Act and the Proceeds of Crime Act. And I would also like to point out that the Proceeds of Crime Act itself provides that certain departments should share information with the FID in pursuance of its function. So that is also a potential conflict with the provisions of this Act. So we believe that the exemption that we have recommended would alleviate those potential conflicts.
Thank you very much, Ms. White. Any questions, Ms. White?
Yeah, Chair, just one point. I think the last point that Ms. White made is important because there are provisions, I think, for mandatory sharing of information in the Integrity Commission Act as well amongst law enforcement agencies. I mean, we want to avoid these silos which have in the past inhibited the effectiveness of the anti-corruption entities. So I think that's a very important point. And the other point I'd make is that traditionally the courts have had a very deferential approach to national security issues coming before them, for example, evidence and so on, which are certified to be subject to public interest immunity. The courts have typically not attempted to go behind that kind of position taken by the executive on national security matters. I mean, it's not an absolute situation, but there's a strong deference there. And if we create a statutory regime where the minister's position on an exemption in relation to national security matters is challengeable in the courts through an appeal, I think the issues that have been raised by the FID, the potential way in which that could be used by organized crime, which are typically well-resourced and can pay lawyers to fight these things, it would be a compromising situation for us. So I think we should take their submissions very seriously, Mr. Chair.
Sorry, just one comment, and to reiterate something I had raised before. the EU makes exemptions for the judiciary and the security forces in terms of their own data protection legislation. In fact, they have a completely separate regime that addresses it. And I think in terms of, instead of trying to ensure we are covering with the exemptions, we may need to look at just a separate regime for those entities, which would include like an FID.
Very good point. Thank you very much, Ms. White.
Thank you.
Let me just use this opportunity because Mr. Barnes, and I don't remember the name of your colleague beside you.
Mrs. Gibson.
Okay, Mrs. Gibson, you made a statement earlier that the U.S. doesn't have any data protection act. Federal, okay. But I myself just did some research, and notwithstanding the fact they do not have that federal data protection act, they have a number of acts that speaks or offer similar protection. In fact, you have the U.S. Privacy Act, the Safe Harbor Act, which was just recently amended, and a framework was developed, which is called the Privacy Shield Framework, that deals with sharing of information between U.S. and EU. And of course, you have the Health Insurance Portability and Accountability Act. So while they do not have a definitive data protection act, they have a number of other acts that offers that level of protection to their citizens.
Absolutely.
So it will be good reading as well.
We do also have various legislation in place. Thank you, Mr. Chairman. I concur. Thank you.
To the presenters here. We have one more? Oh, sorry, Mr. Phillips, where are you? Oh, we did not recognize you at the outset, so let me apologize, sir. Mr. Phillips. In fact, you were supposed to be the first. You were supposed to be the first presenter, Mr. Phillips, but no one had indicated to us that you were present at the time. So, we'll take Mr. Delton Phillips at this time. Right here, Mr. Phillips, right here. Come to the front.
Good morning. Thank you very much. All right. So thank you for the opportunity to present. I'm a software development professional. I've been in software development for about 17 years. I've worked with quite a few institutions here and overseas, where I've worked in a few countries. So I'd like to give some feedback from a practitioner's point of view on the importance of the Data Protection Act. So I actually went through the Act and just highlighted some points. The first one that I had was essentially a question where when I read the Act, it sounded as if it focused a lot on the health and education. I didn't see any provision in there for financial companies. For example, if you're a bank or if you are a building society or any company that's holding that sort of data, I didn't actually see that explicitly mentioned in the documents. I'm not sure if there was if it was supposed to be there, and I would suggest that institutions such as those should also be included. I mentioned that a tax exemption. I'm asking for a tax exemption for companies that engage in training to improve the protection of data, improve the protection of data for their company. Essentially, it's more or less left up to, based on reading the Act, everybody just needs to figure it out. But I actually think what needs to happen is that there should be some encouragement or some guidelines to force companies to actually send employees on mandatory trainings and so on to actually understand how to do it, because it's not just you have lawyers, you have doctors, you actually need training. It's not something you just get up and figure out, and it's very complex to protect data. I had some points there. Point 2, which was whether there was any oversight for the Information Commissioner. I didn't see something explicit that spoke to who the Information Commissioner is accountable to. There was another one, point 3 I have here, the first schedule 4, suggests any person, I'm suggesting that any person once dead or alive, there needs to be some law that actually handles their data even after death. It didn't explicitly speak to someone who has died, what happens to their data and how that data is managed. Some folks spoke already. The Broadcasting Commission spoke about the fines. My point here is that fines are onerous without many safeguards to protect the citizens' data before a breach occurs, which means more emphasis, in my opinion, should be placed on training, certification, and continued education. Professional learning credits should be what the data controller and the processors are actually working towards. So in other words, there needs to be enough guidelines for the data protection, for the data processor and the data controller, that they must be continually learning about how to protect data and how to essentially evolve as time evolves. My experience in industry is the issues that were faced 5 years ago are not the same issues that we're facing now. It is totally different. And the scale of the issues that we're facing, you have more automation actually trying to do the crimes versus an individual who is doing the crimes. So people are writing software to behave like human beings, to log into bank accounts and to transfer money and so on. And these things are fairly easy to be done as once you are a pretty good software developer. Number 5, I had, it said each data protection, I mentioned that for the appointment of a data protection officer, each data protection officer should maintain a security log that contains proactive measures taken, training initiatives, defensive measures, notifications, activities surrounding the protection of personal data. My recommendation is that these things are actually in the law itself, which actually puts more responsibility on someone once they know it's in law. If it's a suggestion that you should do it, my fear is that people may not do it because they will not get prosecuted for it. That's a suggestion. Number 6 here, there should be a requirement for the data controller to aptly demonstrate the ability to conform or meet one internationally accepted standard for data protection in order to be registered, or must suitably satisfy the commissioner that they have the requisite knowledge to be able to protect said data. In other words, somebody should not be appointed to be a data controller or a protection officer if they have no qualifications in the area, because it is a technical skill. Similar to, you would never have a doctor who has never gone to medical school, right? There was some requests for temporary exemption from manual data held by public authorities. I agree somewhat to this with this clause, but along with this clause, it should be a requirement for the entities to outline via roadmap how they plan to secure said data. So if they want to be exempted, then they need to explicitly state how they intend to secure the data. And if it's a 3-year period, what are the steps that they're going to be putting in place to get to where they need to get to within that 3-year period. Some questions and nuances I also had, which hopefully this is not too technical or too boring, but if a minor presents themselves via an existing application, and this is speaking about minors, if a minor presents themselves via an existing platform as being above the legal age to share data and services, for example, somebody could go on Facebook and sign up and say they're more than, I don't know what the limit is, I think it's 13. But that data is actually brought into an application. For example, a Jamaican software developer builds an application that can import data from these applications under the premise that the person was at a legal age and stores that data. Is the data controller in that case exempt from any sort of prosecution for bringing in data for a minor, because in the law it states that if the person is less than a certain age, you're not, I don't have the exact act here, but it speaks to what data you can share for minors. So, but if the minor presented themselves as someone who was 18, like lying wellness, signed up and so on, and that data is shared, and the police discover that this person is actually a minor, but it's my application, am I liable by law because I shared the information of a minor, or allowed a minor to share their data? So that's the concern I have. If a minor shares their data via some existing platform, like a school platform where they're sharing some of their personal information in a social way, and it happens that some of the data that they've shared is some of their biographical data, biometric data, not biometric, biographical data, is there any transition of the act by me, the developer? So that's the other one. Number 10. All right, I'll skip that one. Number 11, there needs to be classifications relating to the volume and sensitivity of data. Data related to minors and the most vulnerable, for example, the HIV or other people with diseases, must have the highest standard, as the impact on a breach of these categories would be catastrophic. So I actually think that those types of data should be treated as separate in a different way than, for example, it was mentioned like the brownies data. It can't be the same. It can't be of the same classification. In the legislation itself, in the act, I didn't see words that spoke to securing, encrypting, speaking to hardened infrastructure, speaking to educational awareness, preemptive approaches, ongoing training, and audits, which are a big part of data protection in general when the rubber hits the road. So I think that the bill should contain words that convey the need to get ahead of any issues before they occur. So in speaking to educational awareness, teaching people about security, having training plans in place. So if a company has a data controller, the law needs to ensure that they are actually doing active awareness training. They're actively training their staff members who are protecting the data. I'd love that to be a part of the law itself, not just left up to the commissioner, for example. Right. While I understand that the data may reside digitally or in other formats, I think there is a need to speak to hardening the infrastructure, such as physical buildings, network equipment, and the utilization of encryption standards in reference to digital data. For example, a minimum of 1024-bit encryption should be required for data in transport. Data at rest must conform to international standard for encryption, and there must be set up a minimum standard for data exchange, data accessibility, and data storage to be defined by the commissioner. But there must be some minimum standards that guides everything. And the data controllers must set aside a cash provision or pay into a data insurance scheme or have a fixed time to provide evidence to the authority that they have satisfied some credentialing body on data security, or have a minimum of 100 hours of CISSP, which is the Certified Information System Security Professional designation. So it's an international designation, recognized worldwide. It's like the base standard for information security professionals right now. So I think that all data controllers need to be able to demonstrate this. I think there needs to be a separate Health Data Act akin to the HIPAA standard in the US, which explicitly speaks to data at rest, data in transit, and under what circumstances data may be shared. So I think that needs to be a separate act all to itself. So these were the points that I had to make.
Thank you. Thank you very much. Mr. Phillips, are there any questions, members? So Mr. Phillips, any questions? Thank you very much,
Sure.
Mr. Phillips. Oh.
Not on Mr. Phillips generally, not specifically, but just more generally. And I don't know how we can do this, but I think there is a need for us to engage in some broader public education about the provisions in the Act. I'm very happy with the number of submissions and the effort that the individuals and entities have taken so far. But I would say, maybe 1% of the population has any awareness of this apart from us inside here. So I think it's something that needs to be considered probably in the interregnum between the close of the Joint Select Committee before the Parliament looks at the report in full, whether it be the technical staff engaging in presentations to different groupings so persons can be made aware of the provisions, because the Act itself, if the average person reads it, they won't really have any understanding or appreciation of what it talks about.
Thank you, member. Let me use this opportunity to thank Mr. Phillips, representatives from the Broadcasting Commission, the Jamaica Chamber of Commerce, the Media Association Jamaica Limited, and the Financial Investigations Division for taking time out to make the different presentations. I believe that quite a bit is before this committee for us to digest when we end the submission component and start to deliberate on this far-reaching piece of legislation that we are contemplating. Members, do we have any other business? Seeing that we do not have any other business, the date for the next meeting, we are proposing Tuesday, the 13th of March at 10 a.m. Next week, Tuesday, the PAC will meet, so proposing that we meet on the following Tuesday at 10 a.m. before Parliament. Okay. Seeing that we have completed the matters for today's sitting, can I have a motion for adjournment? Moved by Member Robinson, seconded by Member Golden. Those in favor? Those against? Ayes have it. Thank you all for attending.
What happened, Tristan?
Mommy, what is an activist?
Activist? Where you hear that word?
A lady was on the TV and she said she is a children's activist.
Oh, the advocate.
That's what I said.
Okay. The children's advocate is the person who makes sure that people know and respect the rights of children. She also makes sure that they are protected. She